In this video, we're going to be talking about the first section of the rules, specifically the regulation of the legal profession. This portion of the rules makes up 6 to 12% of your total MPRE exam. You'll notice as we progress throughout this course, I'm always going to remind you about the frequency in which the rules we are discussing are tested. A lot of people do not know that this information is available, and by being armed with this information, you can study smart. This way, you can focus on those highly tested sections of the rules. Now, that doesn't mean that you're ever going to ignore or skip over anything, but if you find that you're studying at the last minute, or maybe there are areas of the rules that are more challenging for you than others, if they're a highly tested area of the rules, then you should make sure that you're doing your best to memorize them and, of course, understand them. Because again, by knowing the highly tested areas of the rules, you're truly maximizing your chances of success on this exam. Before we dive into this section of the rules, there is something else that I'd like to point out. We will not be covering every single rule of every single section. Instead, what we've done is we've handpicked certain rules from each section to discuss, and sometimes we have extra examples that we give you, or we point out helpful examples that are already provided in your outline. We've handpicked these rules based on what we find to be very highly tested and those rules that students notoriously struggle with. So let's go ahead and get started. The first section of the rules, the regulation of the legal profession, is all about the regulation of lawyers. The first rule that I want to talk about is the power of the courts and other regulating bodies to regulate us as lawyers, as professionals. The first portion of this rule that I want to point out is about our law-related services. Let's turn to the plain language of the rule first. It says a lawyer is not only subject to the model rules of professional conduct for legal services that they provide, but also with respect to the provision of law-related services. If the services are provided by the lawyer in circumstances that are not distinct from the lawyer's provision of legal services to clients, or in other circumstances by an entity controlled by the lawyer, individually or with others, if the lawyer fails to take reasonable measures to assure that a person obtaining law-related services knows that the services are not legal services and that the protections of the lawyer-client relationship do not exist. Some examples of law-related services would be things like financial planning or accounting or social work. So what does this mean? This rule is essentially saying that if you're a lawyer and you have a firm, and you're also offering some other sort of services to your clientele, if you're not taking steps to keep your legal practice separate and distinct from your other non-law related services, you will not only be subject to these rules for that legal work, but also with respect to your clients for those non-legal related tasks that you do for them. So if a lawyer wanted to make sure that they're not subject to these rules for their non-law related work or services, then they should take steps to keep their services separate and distinct. Let's look at the example in the outline. It says a lawyer who's also a certified public accountant or CPA will be subject to these rules in any accounting transaction that he does for an accounting client if he does not keep his accounting services separate and distinct from his law practice. So if he's offering these services in conjunction with his legal practice or not making clear that he doesn't or isn't offering legal services in relation to his accounting services, he's subject to these rules for all actions that he takes. This is a good time to take a quick second and point something out about these rules. These rules place the burden on us as the professionals. We're the ones that have to take steps to ensure that when we're working with the public and when we're working with our clients, that those people understand what kind of relationship we have with them, if any at all. So for instance, if you're not entering into an attorney-client relationship with someone, then the burden is on us, the professional, to make that clear. Or using this rule for an example, If someone is a lawyer and an accountant and they want to offer accounting services that are separate and distinct from their law practice, then the burden is on that lawyer, the lawyer accountant, to make that clear. Why? And the answer to that is to protect the public. We, as the professionals, are in the better position to make these clarifications and to make our position clear, so we should be the ones doing that. And when we fail to do so, we could be, unfortunately, violating some of these ethical requirements and, as a result, find ourselves in trouble. The next rule that I want to point out is getting at regulation after we're admitted to the bar, and it's talking more specifically about lawyer discipline. I want to give you an overview of the disciplinary process to start. This way, if you get some questions about this process or if you see the process being referenced, you can have a good big picture in your mind about what they're talking about. So let's talk about this overview. The first step in a disciplinary proceeding begins when a complaint is made. So maybe it's an ex-client that's mad at you for whatever reason, and they file a complaint with the state bar. Oftentimes, there's a committee, such as a grievance commission, that receives these types of complaints. Now, the filing of these complaints are privileged, and you, as the lawyer or any lawyer, cannot use the filing of that complaint as the basis for some sort of defamation action or any other action against the person that filed the complaint. And if you're wondering why, the answer to that question is because then this process would be very flawed. We need the public to be able to make complaints and be protected if they choose to do so. So step one of this process, a complaint is made. Step two, these complaints are screened. The purpose behind this is to try to weed out those frivolous complaints. We know that unfortunately, people do make frivolous complaints against lawyers. And lawyers shouldn't be in trouble for what someone alleges if it's not true or if it's in fact frivolous. For instance, maybe the lawyer didn't do anything wrong at all. So it's the board's job or that grievance commission's job to decide which complaints have merit and which don't. Those that do not get set aside. Now, if they decide that a complaint does in fact have merit, then it's going to proceed to a hearing. At this point, the lawyer is notified that there has in fact been a complaint made against him or her, and that lawyer is going to be entitled to due process during these hearings. Usually at this point, the lawyer hires a lawyer to represent them. The party trying to prosecute, so to speak, the attorney has the burden to prove that the lawyer did something wrong. So in other words, the lawyer doesn't have to come to the table and show that they didn't do something or that they complied with their ethical obligations. Instead, it's going to be on that grievance commission or on the state bar to prove that the lawyer in question did something wrong. Now, the third step in this whole process is that committee is either going to dismiss the charge or recommend a sanction. They decide that you did something wrong, and then they decide how they're going to proceed as a result. Or maybe they decide that there hasn't been any wrongdoing, and that's the end of it. So that's the overview of our disciplinary process. Next, let's talk about our disciplinary authority. The rules tell us that a lawyer is subject to discipline where he or she is admitted. A lawyer admitted to practice in this jurisdiction is subject to the disciplinary authority of the jurisdiction where he or she is admitted, regardless of where their conduct occurs. So to stop there, let's say a lawyer is admitted to practice law in states A and B, and a lawyer steals her client's money in state A. So this rule says that though the bad act occurred in state A, because this lawyer is licensed to practice law in both states A and B, the lawyer can be subject to discipline in both states, A and B, even though the lawyer did not do any sort of wrongful act in state B. Moving on to the next part of the rule. It states lawyers are subject to discipline where conduct occurs. A lawyer not admitted in the jurisdiction is also subject to the disciplinary authority of the jurisdiction if the lawyer provides or offers to provide any legal services in the jurisdiction. It goes on to tell us that we're also subject to discipline wherever the conduct occurred. So the rule states that a lawyer not admitted in the jurisdiction is also subject to the disciplinary authority of the jurisdiction if the lawyer provides or offers to provide any legal services in that jurisdiction. The example in the outline states, if a lawyer advertises in a jurisdiction where he or she is not admitted to practice law, then that jurisdiction is able to discipline that attorney for the unauthorized practice of law. Note that the jurisdiction where the lawyer is admitted would also be able to discipline her as well. So the big takeaway from this rule, and it's something that we see come up a lot on MPRE questions, is that a lawyer can be subject to discipline in more than one jurisdiction for the same conduct. So think back to that example I gave you about a lawyer being licensed in two states, states A and B, and she stole her client's money in state A. Well, since the lawyer is licensed in both states A and B, the lawyer can be disciplined in both of those places. Thus, one bad act could amount to two different versions of discipline. The next portion of this rule discusses a choice of law issue. And much like the other portions, it's a bit loaded, so we're going to take it piece by piece. The first part of the rule says, in any exercise of the disciplinary authority of the jurisdiction, the model rules of professional conduct to be applied shall be as follows. First, for conduct in connection with the matter pending before a court, the rules of the jurisdiction in which that court or tribunal sits will apply. So let's stop there. I will explain what this portion of the rule means with an example. So let's say that you're representing a client in a personal injury action in court in state A, and you steal their money. Well, because you're representing that client in a matter that's pending in front of a court in state A, you'll be subject to the rules in state A. The rule goes on to say, for any other conduct, the rules of the jurisdiction in which the lawyer's conduct occurred, or if the predominant effect of the conduct is in a different jurisdiction, that the rules of that jurisdiction will be applied to the conduct. Again, let's stop there. If you're a lawyer that does transactional work for a client, and therefore you're really never in court or in front of a tribunal, then this portion of the rule may be speaking to you and your type of practice of law. So for instance, wherever your conduct occurs, the rules of that jurisdiction will cover your actions, or wherever the predominant effect of your actions are. The rules of that jurisdiction are going to be applicable with regard to your actions. Now, there is one exception to the rule that I would like to point out. It says a lawyer shall not be subject to discipline if the lawyer's conduct conforms to the rules of a jurisdiction in which the lawyer reasonably believes the predominant effect of his conduct will occur. I always like to think of this as a rule that rewards lawyers who are doing their best to make sure that they are in line with their obligations under the rules and the law. If a lawyer believes that the predominant effect of their actions will take place in one jurisdiction, and they take steps to conform their actions to that jurisdiction's rules, then we're basically going to give them a get-out-of-jail-free card, so to speak. So if it so happens that the predominant effect of their actions happen elsewhere, and maybe they're not in line or in compliance with the rules in that place. Let's turn to the example in your outline on this point. It says that Attorney Andy is admitted to practice in jurisdictions A and B. Jurisdiction A permits lawyers to participate in for-profit referral services. Jurisdiction B does not. Attorney Andy would not be disciplined by Jurisdiction B if he chooses to participate in a for-profit referral service that only refers him cases that take place in Jurisdiction A. Why? Because his actions or the predominant effect of his actions are occurring in State A, and he's in line with the rules and the requirements in that jurisdiction. The next part of this rule discusses the effect of sanctions in one jurisdiction on another. The rule differentiates the difference between states because those are different jurisdictions, and between our state court and federal court systems because, again, those are separate and distinct as well. So getting to the issue between the states. The rule says that sister states generally accept disciplinary action by one state as conclusive proof of misconduct, but they may apply their own sanctions for the misconduct. So let's stop there. Let's say that I'm licensed to practice law in states A and B, and I steal my client's money in state A. And state A gets a complaint about me, and they investigate me, and they find out that I did, in fact, steal my client's money. So they decide to suspend my license and to fine me. Well, what is state B going to do? Remember, they too can take action against me because I'm licensed there as well. Well, we just learned what will happen pursuant to the rule. What they're going to do as a sister state is they're not going to reinvestigate the allegations made against me because state A already did that, and state A already determined that I did in fact do something wrong. In other words, state B is going to take that as conclusive proof that I did in fact commit a rule violation. So the only thing state B is going to do is to determine what type of discipline they're going to subject me to. Maybe they disbar me because maybe in jurisdiction B, stealing a client's money is considered a very serious offense. Or maybe they simply suspend my license. Or maybe they don't do anything at all. The big takeaway here is that they are not going to reinvestigate me. So let's compare that to the rule of federal courts. The rule says the fact that a state disciplined a lawyer is evidence of misconduct in a federal proceeding. But the federal court must make an independent evaluation. So in other words, the federal court is going to take steps to make their own independent determination based upon their own investigation on whether or not I did anything wrong. They're not going to take a state's investigation as conclusive proof that something actually occurred. Now we're moving on to misconduct, and this rule is really important because it outlines the definition of professional misconduct. The rule states it's professional misconduct for a lawyer to violate or attempt to violate the model rules of professional conduct, knowingly assist or induce another to do so, or to do so through the acts of another. So let's stop there. This means if you violate the rules, that's the most straightforward definition of professional misconduct. It also means if you help your paralegal or your secretary violate the rules, thinking that you won't get in any trouble because you didn't technically violate the rules, you're wrong. That is still considered professional misconduct. Or if you induce someone into violating the rules, you just committed professional misconduct yourself. So the big takeaway is even if you don't directly break these rules, but you help someone else or you induce someone else into doing so, it is still going to amount to professional misconduct. Getting back to the rule, it states that it's professional misconduct to commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So let's stop here again. It's very clear based on the comments of the rules that offenses involving things like violence, dishonesty, breaches of trust, or serious interferences with the administration of justice are very clearly included here. Additionally, repeated offenses, even an otherwise minor offense, if repeated, can indicate an indifference to the legal obligation and get you in trouble. Thus, committing a criminal offense doesn't automatically mean that you've committed professional misconduct. It really depends upon the type of offense and if it's one that you've committed before or not. Turning to the example in the outline, the first one states, Larry lawyer cheats on his income taxes. Even though this has no connection with his law practice, he's subject to discipline. Why? Because cheating on your taxes is fraud. It's lying. That's a huge indicator about this lawyer's lack of honesty, trustworthiness, or fitness as a lawyer, and therefore it amounts to professional misconduct. Compare it to the next. Attorney Allen was caught driving slightly over the legal limit for intoxication and convicted of driving under the influence. A single offense may not be sufficient to be professional misconduct. However, if this same incident happens more than once, it may result in discipline. Why? Because again, we have a relatively minor offense here, and an isolated event, if it never happens again, might not necessarily raise a question to this lawyer's honesty, their trustworthiness, or their fitness in other respects. But a pattern of repeated offenses tends to look like he has an indifference to the law, and therefore an indifference to the legal profession, and that is therefore professional misconduct. The rule goes on to further define professional misconduct as engaging in conduct involving things like dishonesty, fraud, deceit, or misrepresentation. So if you get caught cheating on the bar exam, that's professional misconduct. Professional misconduct is also engaging in conduct that's prejudicial to the administration of justice. So in the course of representing a client, if you manifest by your words or by your conduct any sort of bias or prejudice based on things like someone's race or their sex or religion or national origin, disability, socioeconomic status, sexual orientation, any of those things would violate this rule. It's also professional misconduct to state or to imply an ability to influence improperly a government agency or an official to achieve results that violate the model rules of professional conduct or the law. So for example, Larry Lawyer can't say that Judge Johnson owes me a favor, if you know what I mean. So if you hire me, I think your case is going to go well. That's a problem. That's implying that he has the ability to get this judge to do what he wants, which is professional misconduct. Finally, it's professional misconduct to knowingly assist a judge or a judicial official in conduct that's a violation of applicable rules of their conduct or law. So now that we've covered this rule in its entirety, I will repeat my tip. I would be very familiar with this rule again, as it outlines how we define professional misconduct. The next rule I want to talk about is important because I find that people have a false sense of confidence with it. The rule that I'm referring to is our mandatory reporting of professional misconduct rule. When I talk to most people preparing for the MPRE, they understand that we as lawyers are a self-reporting profession. We have to essentially tell on one another when we become aware of a rule violation. However, that's usually where most people's knowledge of this rule stops, and I find that they therefore get these questions wrong. To avoid a misunderstanding, let's first look at the plain language of the rule. I will then tell you my approach to answering questions on it, so hopefully you can get it right moving forward. The rule states, a lawyer who knows that another lawyer has committed a violation of these model rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, shall inform the appropriate professional authority. If the lawyer does not report the other lawyer, the non-reporting lawyer will be subject to discipline. The same rule applies for reporting judges. So now that you know the language, I want to tell you what your focus should be on. And in fact, I kind of think of this as like a two-part test. So if I get a fact pattern that I believe is testing this mandatory reporting requirement, the very first thing I look for is whether or not the lawyer in question has knowledge about the other lawyer's rule violation. Why? Because this rule requires knowledge. If you don't know someone broke these rules, then you don't have an obligation to report them. But if you know the rules have been broken, well, now that might trigger this reporting requirement. At this point, you may be thinking to yourself, might? I thought we had to report each other. And that brings me to my next point. Look at the plain language of the rule. Not every single rule violation must be reported. Instead, the rules state that if it's a violation that raises a substantial question to that lawyer's honesty, trustworthiness, or fitness, then yes, you have to report it. But that means not every single rule violation raises a substantial question to a lawyer's honesty, trustworthiness, or fitness. Because if that were the case, then the rule would just simply say that. It would say that every single rule violation must be reported, and it doesn't. So my two-part approach is to first double check that your fact pattern has knowledge. If so, then ask yourself, is it the type of rule violation that raises a substantial question to that lawyer's honesty, their trustworthiness, or their fitness? If the answer is yes, then it has to be reported. And if it's not reported, then the non-reporting lawyer has also committed a rule violation himself or herself. So to give you an example not in your outline, that I think raises very clearly a substantial question about a lawyer's honesty, trustworthiness, or fitness. This is about double billing. Let's say that Adam and Bob work together at the same law firm as first-year associates. One day at lunch, Adam tells Bob that he's been double billing his client, ABC Corporation. He claims that he has to, or he's never going to reach his billable requirement. Bob wonders if he has to report to Adam. Well, under the rule, yes. Adam told Bob that he was in fact double billing a client. So Bob has knowledge of this rule violation. Additionally, double billing a client is fraud. It is the type of thing that raises a substantial question to one's honesty, trustworthiness, and fitness as a lawyer. Thus, this has to be reported. And if it's not, then that non-reporting lawyer has also committed a rule violation himself. The next rule I want to discuss is about multi-jurisdictional practice. I feel like this is a pretty clear rule. These types of rules are great because once you memorize the rule, answering a question that tests the rule will become pretty straightforward. And the reason I think it's a clear rule is because it first tells you what you can't do, and then it goes on to tell you what you can do, specifically on a temporary basis, and then it goes on to give us some exceptions. So again, that helps it be pretty clear. It really doesn't leave us guessing about what this rule means. So let's turn to the rule. The rule states, a lawyer who's not admitted to practice in a jurisdiction shall not establish an office or other systematic and continuous presence in a jurisdiction for the practice of law, unless otherwise permitted by the model rules of professional conduct. This means, for example, if you're licensed in Michigan and not in Ohio, but you set up a legal practice in Ohio, you're breaking the rules because you're not licensed to practice law there. It further goes on to tell us that a lawyer who is not admitted to practice in this jurisdiction shall not hold out to the public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. So for instance, if I'm licensed here in Michigan, but I tell people that I can do work in Ohio and I advertise in Ohio, when I'm really not licensed there at all, that would be a problem. Under this rule, if you do any of these things, it technically amounts to practicing law without a license, or the unauthorized practice of law, and therefore it amounts to a rule violation. Now, the next part of the rule talks about 4 instances in which you can practice law in a place you aren't licensed, but only on a temporary basis. You want to be familiar with these 4 instances. The rule states, a lawyer admitted to practice in another United States jurisdiction and who is not disbarred or suspended from practice in any jurisdiction may provide legal services on a temporary basis on 4 bases. The first is if it has a reasonable relation to the lawyer's practice. If a lawyer's services are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice, then temporary practice is permitted. So turning to the example in our outline on this very point, the officers of a multinational corporation survey potential business sites, and they seek the services of their lawyer who's not licensed in the jurisdiction in which they're surveying and assessing the relative merits of each. The lawyer can help them, despite not being licensed in that jurisdiction, in assessing the relative merits of each site. Why? Because it bears a reasonable relation to the lawyer's practice in the place in which they are licensed to practice law. The second instance where you can practice law temporarily without a license is when a lawyer associates with a lawyer who is admitted to practice in this jurisdiction and who actively participates in the matter. To me, this rule makes sense because the lawyer licensed to practice in this jurisdiction is essentially overseeing the matter. And because they're involved, they then have some skin in the game too. This way, the rule ensures that things are going to go smoothly because the lawyer licensed to practice in this jurisdiction is incentivized to make sure the lawyer practicing in this jurisdiction on a temporary basis does everything correctly. The third instance is mediation or arbitration arising out of your home state practice. A lawyer may participate in a mediation, arbitration, or other alternative resolution proceeding in this or another jurisdiction if the services arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice. So here, if there's any sort of mediation, arbitration, or alternative dispute resolution, and it's related to or it arises out of your home state practice, meaning a place in which you are licensed to practice law, you can work on that mediation or that arbitration or alternative dispute resolution. An example of this is if one of your clients that you regularly represent in your home state, where you are licensed to practice, decides to arbitrate a matter in a different state where you are not licensed to practice. You can handle that arbitration for your client. Finally, if you have special permission to practice, a lawyer may ask to be admitted to a tribunal for a temporary basis. A lawyer who is admitted or expects to be admitted pro hac vice may engage in activities in the state such as meeting with clients, interviewing witnesses, and reviewing documents. The last portion of this rule are the exceptions, where a lawyer may hold an office or work in a jurisdiction. In other words, the times in which you can practice law in a place where you're not licensed and not necessarily just on a temporary basis. The rule states a lawyer in good standing who is admitted in a different state or foreign jurisdiction may have an office or other systematic and continuous presence in this jurisdiction if the lawyer is employed by only one client. But if that lawyer wants to litigate, he or she must seek to be admitted temporarily or pro hac vice. So to stop there, let me give you a quick example. Let's say you work as in-house counsel for a company, then this exception applies, or as a government lawyer. Now, the second instance where you can hold an office, even if you're not licensed to practice law in that place, is if you're permitted by state or federal law. So a classic example here would be immigration law, for instance. If you're licensed in the state of New York and you move to California and you want to practice immigration law, then you don't have to take the California bar exam. Why? Because immigration law is federal law, and therefore the fact that you're licensed in one jurisdiction allows you to practice that area of law anywhere. The next rule is a little bit different. Now we're talking about money. The rule we're specifically going to discuss is a fee division with a non-lawyer. So the general rule to familiarize yourself with is that a lawyer or a law firm shall not share legal fees with a non-lawyer, except in the following circumstances. The first exception in which you can share legal fees with a non-lawyer is death benefits. So an agreement by a lawyer with the lawyer's firm or their partner or their associate to provide for the payment of money after the lawyer's death to the lawyer's estate or to a specified person. So if you and I own a law firm, and let's say my husband is not a lawyer, and we agree that when I die, you're going to pay out $100,000 to my spouse. And when you die, I'm going to do the same. I'm going to pay out $100,000 to your spouse. We can do that. So when I die, you're technically going to be sharing fees with a non-lawyer when you make that payout to my husband. But you're permitted by virtue of this exception. The next exception, the sale of a law practice. A lawyer who purchases the practice of a deceased, disabled, or disappeared lawyer can pay the agreed upon purchase price. 3. Retirement plans for non-lawyer employees. Lawyers or law firms can include non-lawyer employees in compensation or retirement plans, even though the plan might be based in whole or in part on a profit-sharing arrangement. Why? Because this rule recognizes that law firms employ people that are not lawyers, and we need to be able to pay them and compensate them accordingly. Similarly, the next exception, bonuses for non-lawyer employees. A lawyer or law firm may give out bonuses to non-lawyer employees that are based in whole or in part on how much money, including legal fees, the overall firm has made over a period of time. Again, you can do this with your paralegal or your secretary, though they're technically not lawyers. And then lastly, sharing court-awarded fees with a nonprofit. A lawyer can share those court-awarded legal fees with a nonprofit organization that employed them, retained them, or recommended employment of a lawyer in that matter. So turning to an example on this point, let's say a homeless man got denied access to a homeless shelter on the coldest day of the year, and he was very angry by virtue of this situation, and he sought the help of a legal services organization. The legal services organization recommended that he reach out to a specific lawyer because this lawyer frequently does pro bono work for people that were associated with the legal services organization, and sometimes the lawyer did pro bono work for the legal services organization itself. So the homeless man reached out to this lawyer, and the lawyer agreed to represent this man. The lawyer successfully litigated this man's case and won him money, and the court awarded this lawyer $10,000 in legal fees. The lawyer was allowed in turn to share in some of those legal fees with that legal services organization that recommended his services to the man. This is permissible, even though technically the lawyer would be sharing fees with a non-lawyer. The next and final rule I want to discuss in this section is the sale of a law practice. A lawyer or law firm may sell or purchase a law practice or an area of a law practice, including its goodwill, if all of the following conditions are satisfied. Let's talk about each of these requirements, and then I'll give you an example. The first requirement is that the seller ceases to engage in private practice of law or in that area of practice that's been sold in that geographical area in which the practice has been conducted. To stop there before we even look at any exceptions. If I own a law firm in Detroit, Michigan, and I want to sell you my probate portion, I can do that. That's a portion of my law firm. When I sell you that probate portion of my practice, I cannot practice probate law in the Detroit area anymore moving forward. I have to cease to engage in that private practice of law in that legal area. Now, there are some exceptions. The first is if there's a return to private practice as a result of unanticipated change of circumstances. This might not necessarily result in a violation. The example in your outline states, a lawyer who sold their practice to accept an appointment to judicial office does not violate this requirement if the lawyer later resumes private practice upon being defeated in a judicial election. The next exception is it does not prohibit employment as a lawyer on the staff of a public agency or legal services entity that provides legal services to the poor or as in-house counsel to a business. So if you sell your practice to go in-house, you can do that, even if it's in that same geographical area, or if you sell your practice to go work for a nonprofit entity or legal services entity, you can do that as well. The final exception is, remember, you can sell an area of your practice. So if I sell only the probate portion, like in that previous example I gave you, then I can still practice other types of law in that geographical area. So that's our first requirement. The second requirement is that the entire practice or the entire area of the practice is sold to one or more lawyers or law firms. This means they take nothing or everything. They are not allowed to go through your files and just take those that generate more fees than others. The next requirement is that the lawyer has to give written notice to each of the seller's clients regarding notice of this proposed sale, the client's right to retain other counsel and to take possession of their file, and the fact that the client's consent to this transfer will be presumed if the client does not take any action or otherwise object within 90 days of receipt of the notice. And then the last requirement is that the fees charged to existing clients shall not be increased by reason of the sale. This means if you're the lawyer selling your practice and you have fee arrangements with your current clients, whomever buys your practice has to respect those fee arrangements for as long as that original agreement stated. Now, if they take on new clients, they can charge those new clients whatever they want. But the idea is they have to respect the fee arrangements that are already in place with those existing clients. So that wraps up the first section of the rules, the regulation of the legal profession.